Currently, if an employer wants to change employees' terms and conditions and doesn't have the employee's agreement or a contractual right to make the change, it has the last resort of fire and rehire. So fire and rehire is the process of dismissing an employee who refuses a contractual change and then immediately re-engaging them on the new terms. But from January 2027, fire and rehire will be an automatically unfair dismissal in most cases. And that's a significant change from the current position, and it's a much tougher approach. So under the current rules, fire and rehire can be a fair dismissal, as long as you can show you've got a genuine business reason for making the change, that you've consulted properly with the employees, and you've followed a fair process. And the new rules will apply where the employer is trying to change terms relating to pay, hours, holiday, or pension arrangements. And it will be an automatically unfair dismissal to dismiss an employee and re-engage them on the new terms where the purpose is to vary these core terms. So there will only be one possible defence to an unfair dismissal claim. You would need to show that you're in serious financial trouble and that your ability to continue operating is at threat if you don't make the changes. So that's a high bar to meet. And the main point for HR is that making contractual changes is about to become more difficult with fewer options for moving forwards if employees refuse the change. So what can you do now to prepare? Well, don't wait until next year. Review your contracts now. Look at any variation clauses that you currently use and think about whether these give you the flexibility that you need. And if you don't use variation clauses, then look at including these in new contracts and start planning how you'll achieve change through consultation and agreement rather than fire and rehire.